concerning the site visits. Mr. Masters, Mr. Cottle, do your clients have any objection to a representative from the parish councils going on the sites? And Mr. Masters?
No, sir. But what we prefer is not a lot of representatives from the parish council. So perhaps if yes, no problem with that. So we do what we. No, because there's two parish councils. So okay. Yeah, we're not. We wouldn't want a lot of people. May I just mention, sir, that Mark Doherty won't be on site tomorrow because he's attending a funeral. His wife will be, but he wanted you to know that there wasn't any discourtesy by not being there, but he's attending a funeral.
Yes, understood. And secondly, on site visits, I mentioned last week that I have no transport. Have arrangements being made for me to be accompanied by representatives of both main parties to get to the site?
Well, I'm happy to facilitate that, sir. If we agree a time and a meeting point somewhere close to here. Yeah.
Thanks, Mr. Woods.
And obviously, I don't know who's attending from the council, Mr. Ward, presumably.
I'm assuming it'd be Mr. Ward. So you're happy to do it? Yeah. Excellent. Yeah. Thank you.
Sorry, so can I just correct when I said Mark, I meant Matthew.
Okay, thanks, Mr. Masters. Councillor Sullivan, I don't know whether the parish councils want to take it up, but I wanted to check whether a representative of all 4 parishes would like to come on the site visits, as you've been involved in the inquiry. That's fine. Yeah, I was only thinking of one person to represent all 4 parishes. Yeah, so that will be sometime tomorrow. And arrangements will be made at the end of today. Right.
The email just containing the site visit list that you asked about. The email that was sent.
I see. Yeah, that's what Mr. Bennett's handing up is the covering email, which concerning the site visits, which went to Miss. I can see it's gone to Mr. Woods. Of course, yeah. If you remember, I asked for the plan had been changed. I think the original one showed the wrong part in Lydia Park, and I asked for an update, and that came through with the covering email.
Maybe we can come back to this, sir, after Mr. Woods is finished in chief.
Yes, I thought you just wanted to check what I'd got.
What am I checking?
Well, it's just.
I was just showing you what I'd been given. That was all.
Well, I want to have a look.
Sorry?
I was given a plan.
Yes, and there was a covering email with the plan which went to yourself. The email says it went to you anyway.
Yeah, I think Mr. Woods.
When was that then?
Sorry?
When was it?
Mr. Cottle's got it with the date, and I haven't got it anymore.
18th of June. I'll ask for that back if I may.
Of course, yeah. Okay. Right, Mr. Cottle, it's your examination in chief with Mr. Woods, please.
Thank you. Mr. Woods, if I could begin with the tilted balance, please.
Yes.
And in footnote 7, as you're well aware, it refers, perhaps you could turn up paragraph 11 of the MPPF, I don't know. I read it to you. Where there are no relevant development plan policies, or the policies which are most important for determining the application are out of date, granting permission unless the application of policies in this framework that protect areas or assets of particular importance. And it goes down and it says policies referred to in this framework relating to habitat sites and or designated as sites of, and then it includes national landscape.
Yes,
And the point is, difference between the parties is whether footnote 7 should apply to land outside of the national landscape.
well, no, I don't believe it should. I think it's quite clear what the footnote says in terms of landscape. Otherwise, it will be everywhere.
Now, if we presume that the inspector is for some reason persuaded that the tilted balance doesn't operate,
Okay,
and we know that before the December 2024 changes to the PPTS, the tilted balance wasn't even available. Travel appeals.
that's correct, yeah.
And if you bear in mind that the inspector has got before him the various submissions on countryside that I don't want to go over, but it was talking about an incongruous promontory, and Mr. Dudley was saying that the hedging would be difficult to dig in. He was saying that the ground wouldn't accept it. For some reason, he was saying it wouldn't take quickly. Do you remember that?
I do remember.
That? We
Yeah,
don't want to go back
odd,
over that
yeah.
because the inspectors, but just suppose that the inspector didn't accept that you could have deep digging or whatever the condition would be that we can discuss in the condition sessions that can address that concern. And just suppose that the inspector was with the authority on there being this sort of cordon sanitaire where you don't have any development round the fringe of a national landscape because it's a buffer to keep free of development for the purposes of the national landscape. Just suppose that he rejected our case on doesn't affect the setting or doesn't materially affect the setting, and perhaps the inspector was going down the path of it does materially affect the setting or it does significantly affect the setting. And so therefore he's not applying the tilted balance. He's taken the view that significant weight should be attached to the harm to the landscape. The question is whether the material considerations in favour of the appeal still outweigh that harm to the landscape and on flooding and ecology.
Yeah, I think the balance should be in our favour. The point that the council are trying to put forward is this sort of theoretical buffer zone to the national landscape, but it's not written anywhere that there's any such buffer zone. It's not like an ancient woodland where you would have a buffer zone. Although in some circumstances you can go through that buffer zone depending on need. So I think the need in this borough is so high that even if it was more than the limited harm that I suggest, it shouldn't be a reason for dismissing the appeal. And we know in terms of Pollingford Place that was next to the national landscape, and that was a major part of the council's case when they objected to that when it went to an appeal. And the appeal was allowed, but subsequently the council are suggesting that there should be more pitches there. So it's a little bit odd. And of course, in terms of Lydia Park, they're suggesting, and they've recently granted planning permission for more pitches there, still in the zone of influence, as it were, from views from the national landscape.
Now, if the inspector goes down the path that habitat would be lost by the development or by allowing permission on the site of greater crested newts or wooded white butterfly, what weight should he attach that if he's still of the view that a similar sort of condition as we've seen at Lawn Hill Farm or at Thatched House Farm could be employed? Does he still attach weight to ecological harm, or what does he do if he feels it can be satisfactorily addressed by condition?
I think the key thing is if there was harm caused, and we don't know, the woodland butterfly was outside this area, so it's not identified in this area. But if there was harm to great crested newts, then that has occurred, if it has occurred. And what we're proposing as part of the conditions is a mitigation and enhancement of habitat for the butterflies, so we can widen that out, and mitigation relating to the great crested newts. If the appeal is dismissed, then none of that can be achieved.
Now, I'd like to take you to Mr. Ward's proof, if I may, and
That's CD 8B.
indeed it would be, I think, and it's paragraph 916 that I'm looking at.
So 960.
I believe so. I have it top copy, don't have the index. But if Mr. Woods has got it, it's the, and it's at paragraph 916. Do you have it, sir? That's right.
67, isn't it, sir? Page 67, yes.
And you see there that he refers to the case of Stevens and to Collins, saying that, and in paragraph 915, last sentences, it says, I'm aware of the requirements of the best interest of the children are a primary consideration. Whereas your paragraph 993, you refer in your proof to that no other consideration is inherently more important. And you refer to the AZ case. And I wanted to bring up the AZ case, which is in inquiry document 7.2, sir. Inquiry document 7.2. Appeal for Slowswell Paddock, Westerly Road, Pucklechurch. And it's a decision of Inspector Clive Hughes. And it's at paragraph 43. That's right. ID 7. It was attached to my note on material considerations.
Right, I'm just trying to find this.
Stephen, you're talking about ID 7.2, the Slowswell Paddock one, yeah?
That's right, yeah. Paragraph 43.
Okay, inquiry documents.
ID 7.
ID 7, yes.
Point 2. Pucklechurch.
Oh, point 2, yeah. Okay. Yes.
Paragraph 43.
Yes.
And what is being quoted from there is a decision that's also cited in the High Court case in Waverley before us regarding what outcome or certain course, what would be the course that would be in the best interest of the children. And so whereas Mr. Ward is saying, well, it might be rare, it shouldn't necessarily be decisive, what this decision is saying is where the best interests would favour a certain course, that course should be followed. And what's been said against that is that the concern for flooding and access out of the site trumps that concern. And if the flooding is dealt with by condition or there's a drainage strategy, would that still be the case? Or are the planning authority in right in saying that because of the flooding concern, the best interests are actually to go off the site?
No, no, they can't be right. And the situation could be that family with a child goes off site, they stop in a lay-by, and with cars at a very close proximity to the door to the touring caravan, I know what I would consider to be safer than being at the appeal site. Must be the answer.
And what if the inspector goes down the path of thinking there might be other pictures at Lydia Park that could be available? Is the flood concern improved or not dealt with? If
What's sorry improved?
If the flooding situation is it dealt with or is it left as it is if there no planning permission is granted?
It's left as it is. So the council are continuing to grant permissions at Lydia Park, and then against us they hold the surface water flooding issue. So it's a strange approach. So no, nothing has changed.
And looking down at paragraph 49 of the decision in the Pucklechurch decision, there's reference to human rights. Is that a material consideration in this case?
Yes, it is, yes.
And I'm not going to take you to the 7 or 8 material considerations that you've set out in your proof in several different places. For example, 10.7, you've gone through the lack of 5-year supply, the appellant's status as their personal need, and the consequences of the appeal being dismissed and the lack of alternative sites.
Yes.
Now, I wanted to take you to the opening statement, the material considerations, sir, that were put in. It's ID 0. It's the first inquiry document. And I think it was headed Note on Material Considerations. And it's at paragraph 2.
Yes.
Paragraph 11.
Paragraph 11.
And factors 1, 2, 3, 4 are all relating to issues over the 2017-2018 GTA. But if I could draw your attention to 5, it's sub-regional need, which you covered in your proof. That's right. I've got a top copy here if it would help anybody. And the question to you, Mr. Woods, is sub-regional need a material consideration or not?
Yes, it is, yes.
And what do you say about that?
Well, the sub-regional need is in the sub-region. There are needs for gypsies and travellers, so it goes to the point that I think it was put to me at one stage that, well, when I did the sequential test, why didn't I refer to sites that were just beyond the boundary of Waverley? And my answer to that question was, well, it doesn't really actually achieve anything, even if that was the right approach, it doesn't actually achieve anything because those authorities also have an unmet need.
Now, we know that the need, the assessed need over the planned period is about 200 pitches. Add on some from Legends Acres, the other one, it might be 210. Add on some of non-travellers, and we might be somewhere over north of 220 or 230, but we don't know how much more than it is of 210. But in this case, I understand from Mr. Ward's proof, what he's done in the planning balance is he's got two headings in his proof, which is looking at the factors in favour of allowing the appeal. And he's looking at, and I think I can take you to the paragraph where he's talking about it in the balancing exercise. It's the factors in favour, I think he reduces it down to two, which is the general need for additional sites and the personal circumstances. Whereas if you look at the the opening note that I've drawn your attention to, I think there's about 15 of them. So what I'd like to do is ask you whether health need is a factor.
Most certainly, yes. Needs to be taken into consideration.
And if you think about Huey, he's got particular school, he's got particular needs in terms of support that's obtained. How important is that in this decision for this inspector?
Very important indeed. And I understand you heard from Mr. Simon Doherty relating to how he relies upon the support of others when he's away for any length of time.
And is that relevant to the sequential test?
Yes.
How?
Yeah. Because he needs the support of existing persons, not starting again from scratch from somewhere where he doesn't know those that are living on a particular site or nearby to them. So that could have very serious consequences on Huey's health.
And are there Equality Act race implications in relation to members of a minority and ethnic group where there's a huge amount of accommodation need that's not being met?
Well, it certainly seems that way, yes.
Is that a race equality issue?
Yes, I mean, that's right. It's a serious concern.
And that comes back to whether or not there's alternative place to go to.
Yes.
And what do you say about that?
Well, there are no alternative places for the appellant to resort to.
What do you say about the fact that there are enforcement proceedings going on against non-travellers with vacant pitches? And we know that DS20 is a single pitch. I think DS18 is a single pitch. What do you say about those?
Well, the appellant has made his own inquiries to persons on Lydia Park, and there's nothing available for him on any of those sites.
And how long, if the inspector was minded to adopt the planning authority's case, should he allow for enforcement proceedings against non-travellers?
How long?
Well, if it's dependent on the completion of enforcement proceedings.
Yes, I mean, we don't know how long the process is going to take and whether there's going to be any challenges to it by those persons that have been served with the notice, or whether they agree that they're actually in conflict with the notice. If they say they're not in conflict with the notice, then the local planning authority are going to have to produce the evidence that we haven't seen yet.
In relation to a different subject, domination, I don't want to take you to the PPTS. You know, you're familiar with the paragraph that deals with it. The point is, you know, when you're faced with a statutory provision or a policy requirement, you presume to construe it in a way that Parliament or the government didn't mean it to have any racist implications. And if you do that, then you could say that 2,600 houses on an aerodrome next to a village without any accompanying infrastructure like shops or whatever might put a totally unacceptable strain on the resources of an adjacent village without any accompanying expansion of shops or schools to cope with housing. There would be an infrastructure issue. Do you see that? If you had a new housing estate next to a village.
I do see that, although there are some facilities proposed at Dunsfold within that allocation.
But if
when they come along, we don't know.
Absent infrastructure concern, is there any real basis to being concerned about different members of an ethnic minority? Absent an infrastructure.
Well, no. I mean, it's. I can't accept that the appeal site will cause an over-domination of the settled community, and
because they're gypsies.
Because they're gypsies, and indeed, actually, that can't be
Mr.
really.
Cottle, there's
be the
no need
council's
to suggest the
case.
answer.
Right.
And that really can't be the council's case, because since the appeals have been going on, and that's been part of the reason for refusal, is the over-domination, they've granted more pitches at Lydia Park. So it seems that when it suits them, they can cast aside their over-domination issues and then bring it in relation to the appeal site.
I believe that you mentioned, I don't know whether it was in evidence in chief, a decision that you had in mind where one inspector took into account the presence of a village that was some distance away for purposes of counting. And it's coming back to this question. The inspector said, well, how can I count aerodrome if there's no houses there? How is it relevant to the question of domination that there might be in 5 or 10 years' time over, well, 1,800, I think, in the first phase, houses there? How should the inspector approach that? If there's domination
on the
now,
basis, well, the development has started, the infrastructure is being in place, planting is being carried out, so the development is going ahead. There's always things to enable it to start with, and I can't see how the appeal site will result in an over-domination combined with existing Lydia Park to a settled population which will be there very shortly. And they didn't consider, well, I don't believe they considered the over-domination of the gypsy and traveller sites by the 1,800 initial houses going in at Dunsfold.
well, I stand to be corrected, but the understanding I got from the parish councillor who spoke on the first day was that the aerodrome wasn't that much further from the appeal sites and many of the settled houses in Stovolds Hill.
No,
of
that's right.
equidistance or even closer.
Mm.
But the point is, how far afield should the inspector be prepared to go when considering the definition of community? What was did you have a decision in mind where there was a village some distance away? What was that?
It was Headcorn in the borough of Maidstone.
And how far was the site from Headcorn?
Must have been 3 miles, something like that, from the appeal site. And there were a number of gypsy and traveller sites on the road close by to the appeal site and scattered housing around. But the inspector took the view that, yes, there is scattered housing, but the nearest settled community was actually Headcorn.
Would it be wrong to ignore the aerodrome?
I believe so, yeah.
Next question, different subject, last subject. If we could go, please, to the historical mapping, Appendix 10 to Mr. Smythe's proof at 8B.5, Appendix 10, page 4 of 7, and you see some pictures that we saw on the day that you were away from the inquiry.
So CD,
8B,
CD8,
the historical mapping, Appendix 10,
CD8B,
point 5.
point 5, Appendix
10,
10.
page 4 of 7.
Okay,
And you should see there 4 of 7. And it's a photograph that we had out in front of the inspector.
tile 4,
And it should be dated July 2021.
yes,
Now, we know from that photograph that the hard standing was down, the ditch had been interfered with, the caravans are brought across.
yes,
Now, if we look at the under report at TB 10, it's in the appeal submission documents, CD 2B. And it's 2B.10, flood risk assessment, under.
so that's CD
2B.10,
2B,
so something that went in with the planning appeal documents.
okay,
And this is well, we've got the date of it, July 23, and then if we go back down to page 14, 14 of 40, just above paragraph 5.2.
page 14, yes,
Yeah, and just above paragraph 5.2,
yes,
there's a plan, and underneath it, it says, the third bit down, the closest water feature to the site would appear to be an unnamed drainage ditch. Now, can we tell from that whether they knew whether the ditch had been interfered with by then and hard standing had been laid across it and caravans had been on the land? Because this is July 23, and we know the injunction began in July 21, 2 years earlier, after caravans were introduced, to that photograph that we've seen, that I just showed you in the historical mapping. So they were don't appear to have caught up with what's gone on.
no, I mean, that's right, they talk about it as a drainage ditch, they don't say that it's been filled, but it would have been at that stage.
Right. Next question is this. If the inspector gets to the position, well, he will get to the position of looking at intentional unauthorized development, and he's satisfied because it's not challenged that when the appellants acquired their interest, the trees had already come down. We've seen that from the photograph I just shown you.
Yes,
Does he lay that at their door, or if they didn't carry out those works, should he conclude that they do or they don't amount to intentional authorized development?
well,
By the appellants.
no, by the appellant. No, the laying of the hard standing, it wasn't undertaken by the appellant, so it shouldn't be laid at the appellant's door for
Well, that's
something someone else did.
That's the trees, the loss of the trees.
And the loss of the trees, yeah.
And the ditch.
And the ditch, yeah. So the only difference is the moving on of the caravans.
Because if the inspector was of the view that they caused the loss, but there's not no evidence of this, then it would be a different matter, wouldn't it? The intentional unauthorised.
Yes, indeed, yeah.
And what are the mitigating features in respect of Simon Doherty and Huey about their arrival on the land?
Sorry, what have they?
What are the mitigating features about why did they arrive at the site? Well, you missed the day's evidence. Your understanding of why Simon had to come to Cranley.
Well, they had a need. There was nowhere else for them to go.
And on the flooding, back in my opening material considerations, that the last thing that I said was in the alternative, a permanent permission is not warranted, whether the above matters are of sufficient weight to outweigh the identified harm over the length of time that would be sufficient for the purposes of a temporary permission. And the inspector has said he's already got your answer on this point, so I don't need to go over it again, but I just need to get the difference between allowing a temporary, well, you could allow a temporary because of a new matter, which we've heard today, is to see whether the PDA is adopted by a new authority. But what I'm interested in is for the purposes of a coherent drainage strategy. What the inspector has got before him is that a drainage assessment was carried out in the Gilbert decision. He knows that much.
Yes.
And he knows that there's Tom Quigg has been employed on another appeal that's not before him at the south of Mark and Matthew's pitches, Barney Doherty. And
Yes.
if he thinks that he can't condition it on a negative grampian, which is that the permission shall cease, lapse, unless they have got a satisfactory strategy agreed with authority. If he wants to just allow a temporary permission until planning permission has been sought for any operational development that be required for reinstating the ditch and the crossovers onto the pitches. How long should he allow?
Yeah, that's why I said the shorter period of 3 years. And I think the inspector picked me up on that point, so well, it's not what you said earlier. But what I said earlier was in relation to the local plan and allocations coming forward through the local plan process and potentially getting planning permission.
Why shouldn't the inspector go for a shorter period of 18 months to allow for a planning application?
Sorry, Mr. Cottle, I'm not quite with you on your question. Did you say why the inspector should go for 18 months?
Well, we're just talking about how long it might take for a planning application in respect of the drainage strategy.
Yes, I understand that, but Mr. Woods has
said
volunteered 3 years.
And I'm saying, well, what if the inspector's thinking of a shorter period?
Oh, I see. Yeah. Follow.
I think it's only going to take
Yeah, so
half that
if the
time.
inspector was considering a shorter period to allow time for a planning application to be submitted to deal with all these matters, then 18 months would be a reasonable period.
I've got no further questions, thank you. Oh, sorry, one other question. You heard about the day room point that I put to Mr. Ward, which is that on Simon Doherty's instructions, if the inspector was concerned about the day rooms, he needn't grant permission for 3 day rooms. He could just grant it for 1 because of his concerns over landscaping.
Yes, indeed. Yeah, the inspector will see that there's 2 types of day rooms. One is a larger L-shaped day room, and that is particularly relating to for the needs of Huey, whereas the other 2 day rooms are for the other pitches that are there and are not absolutely necessary.
And if it was going to be 1, it would be the larger one, I understand.
Yes, sir.
Yeah.
And could that be done in recessive colours so it doesn't glint from the top of it, if it's visible?
Yes, I mean, that will be,
What sort of roofing could it have?
well, it could have, I'm not sure whether it's a pitch roof now, I can't remember offhand.
I think it is. I think there are plans in.
Yeah.
Have to check.
If it's a pitch roof, it could be in a corrugated form, which could be painted brown or green, a dark green colour.
What,
So
Well, you
it'd be
better check
subject to
you better check what
condition.
the details are, Mr. Woods, if you're not
Mm.
sure, or I don't know to what extent they specify.
but would that be something within what sort of condition would involve that?
Generally speaking, that's that's one of the purposes of the condition would be to deal with materials for any buildings, yeah.
Well, maybe we can come back to that in the condition session. I've got no further questions.
Thank you, Mr. Cottle. Mr. Lintock, please.
Thank you, Inspector. Good afternoon, Mr. Woods.
Good afternoon.
Just it's like deja vu, isn't it? We're doing this over and over again. Just a couple of questions for you then at this stage of the inquiry. Firstly, I want to ask you a couple of questions about policy, and firstly about the policy RE32. So that's in the core bundle CD 6.6, whichever A, B, C or D you're in, 6.6.
CDB 0.6.
0.6, yeah.
Yeah. Okay. What's page, please? Internal
So-
page.
If you go to page 127 at the bottom of the page, I don't know what the PDF page is, so you have to scroll through. And 27, so policy RE3,
Ah,
so it's in the bottom right-hand corner of each page.
sorry, the actual
It
page.
might, yeah, Mr. Cottle's going to pass you a hard copy because that'll be, I suppose that's easy.
Well done.
So,
What
so
page
2 is
it?
the right one to highlight, yeah.
Oh,
That's that
okay,
helpful. It's being prescient. So, yes, yeah, so the simple point that I just want to put to you in relation to the bit that Mr. Cottle has highlighted there is
Yes.
that we can see that in respect of areas of great landscape value, you see that it says the same principles for protecting AONB will apply, and those principles are, Mr. Woods, looking above protection and enhancement, aren't they? So that's the territory we're in for AGLV.
That's what it says in terms of that policy, but it's been somewhat superseded by the looking at moving areas of AGLV into ANOB, now natural landscapes, and so that is a local designated policy, and the same weight shouldn't apply.
Where if we carry on reading to deal with that point, it says which will be retained. Do you see that the same principles protecting AOB will apply in areas of great landscape value, which will be retained for its own sake and as a buffer to the AONB. So it's right, isn't it, that the policy contemplates the AGLV being retained for its own sake, not just as a buffer. Not what it says there.
That's what it says there. But as I said, because quite rightly for some time, well, not quite really, it's taken so long, but quite rightly, areas of what is now natural landscape have been looked at for candidates to move into that. And so therefore, that part of the policy is been overtaken by events, really.
But it's still in force.
It's still in force, but we know that piece of land it was not a candidate for a national landscape.
And if we go and have a look, can I turn next to the framework, wherever you've got that, and let's have a look at page 54 of the framework.
Yeah, I've got the
You've got a PDF
earlier
copy.
version in here. You see, that's the trouble,
Okay,
isn't it?
so
It's not been changed.
What you want is paragraph 189 of the current framework.
Second part, current.
Yeah, so I'm happy with that, Stephen. At this stage, just pass it across.
Didn't know you were going to.
We chatted before. So two points to put, and obviously what I'm going towards is what you've said in chief, just so you know where I'm going, about whether or not something needs to be in or inside the national landscape to be a footnote 7 policy. But before we get to that stage, 189 tells us that great weight should be given to conserving and enhancing landscape and scenic beauty in national parks. So that's the first thing we can draw from that policy, isn't it?
Well, that's part of it. Then it's in national parks, the Broads, and national landscapes.
And then when we look down to how that paragraph, so this paragraph of the framework does deal with development within the setting, doesn't it? Because in the second part that Melanie Friend has highlighted, do you see at the end there that the paragraph expressly contemplates that development within their setting should be sensitively located and designed to avoid or minimise impacts. So that's part of that that policy, isn't it?
Yes, it's not worded in the same way as the policy in the local plan. I wouldn't expect it to be. What it's saying is that talking about it's not protecting it for its own sake, so nothing goes there, but looking at sensitively designed to minimise adverse impacts on designated areas. So I don't say that there's no impact, but the impact, what there is, can be minimised by the use of landscaping.
Well, I don't want to go over what we said, what you said previously, but I've noted down that your case is that it needs to be adjacent to be within the setting. That's what you said on the last occasion. So you've not changed that view. So I'm going to put these questions to you on that basis. But in terms of what the policy says, what I've said is that the policy in 189 obviously does also address the development within setting of national parks, doesn't it? In that bit of it, yeah. That last sentence.
Of national parks,
Of
the
189,
Broads, and national landscapes, yes.
Yeah. So
it says what, while development within their setting should be sensibly located and designed to avoid or minimise adverse impacts on the designated areas.
So that's the policy that we see relating to national landscapes. If I ask you to turn to page 6 of the framework and just have a look at paragraph 11, please. Okay. So we can see there in 11D, we've got after the or, where there are no relevant development plan policies or the policies which are most important for determining the application are out of date, granting permission unless the application of policies in this framework that protect areas or assets of particular importance provides a strong reason for refusing. And then if we look at 7 in the footnote at the bottom of that page, the policies referred to are those in this framework relating to, and then we see added in there, a national landscape. Yeah. land designated
Yes,
as. Yeah.
national landscape. Yeah.
So the simple point is that you don't have to be within the national landscape for the policy relating to national landscape to provide a strong reason. It's the policy that one needs to look at to see whether that strong reason is provided, isn't it?
I think you need to be in the national landscape.
Where does it say that?
So sites of special scientific interest, land designated green belt, local green spaces, a national landscape, a national park, heritage coast, irreplaceable habitat.
It's a point for
Habitats.
submissions, isn't it?
Yeah, doesn't say.
So specifically, you took him to it in his chief. So the point is this, that where it's talking about a national landscape, that is preceded by the policies referred to are those in this framework, and then relating to a national landscape. It doesn't say that it needs to be within a national landscape, does it? It's referring to the policies, in this case 189.
Well,
No, don't interrupt, please, Stephen.
well, the policies are set out in the framework. They're not the local plan policies, and it doesn't relate to. This footnote makes it quite clear that it's if you're in the national landscape, you're that's one of the criteria where it wouldn't apply.
So we've looked at.
But we're not in the national landscape.
No, we've looked at policy 189, and the policy in 189 relates to national landscapes. That is the policy being referred to in respect of national landscapes, isn't it?
Well, you can say what you like about it, but it's quite clear in footnote 7. It doesn't say, oh, and adjoining national landscapes. And why would it? It wouldn't do.
So do you want to
completely the wrong approach and make it the whole exercise pointless?
So when it says the policies referred to, if not 189, what policies are being referred to there in relation to national landscapes? What do you want to suggest? Any other ones?
Well, no, the policies are in the framework, but the footnote specifically says relates to national landscape. It doesn't say, oh, and by the way, if you're adjoining a national landscape, and how far away do you need to be adjoining it? It's very, very imprecise.
Does it refer to sites within the national landscape?
It refers to being within the national landscape, yes.
Where do I find that?
It says, and or designated sites of special scientific interest, land sites and those listed in the paragraph of sort of designated green belt, local green space, a national landscape, a national park, or within the broad authority or a defined heritage coast. I mean, it specifically says key things. It doesn't say, and oh, by the way, if you're adjoining a heritage coast, or you're adjoining a green space, or you're adjoining the green belt, or adjoining the Broadlands National Park Authority, it doesn't say that.
So just one further question then, Inspector. So do you recognise that a policy can relate to a national landscape without the site being contained within that national landscape? Or do you say that the policy can only relate to a national landscape if the site is within that national landscape? Which one is it?
Well, it should be related to the national landscape, because it's like you're in the green belt or you're not in the green belt. And a lesser criteria might be, and it says in the framework 189 about other areas that are there, but it's not specific to policies relating to the national landscape.
That's helpful. So I'll just leave it as this then. You've treated footnote 7 there as meaning that unless a site is actually within the national landscape, it can't be covered by policies relating to the national landscape for footnote 7 policies. That's right, isn't it?
Correct, yeah.
Inspector, with that, I'll move on. So the next place that I want you to have a look at, please, is within CD. I'm going to say B, but I think it's any of them. 11B.3. So CD 11B.3. That's the National Landscape Management Policies, Inspector. So it's
Okay.
called the Surrey Hills AONB Management Plan, but obviously it's for the national landscape. So I'm just waiting for the inspector to. Yeah. Brilliant, Inspector. So it's PDF page 17 of 23. It is indeed. And it's the aim that I just want you to have a look at, please, Mr. Woods. So it's right, isn't it, that within the Surrey Hills stroke now national landscape document, the aim in relation to planning is that new development enhances local character and the environment quality of its nationally important setting. So it's right, isn't it, that the setting is recognised within this document as being of national importance. Yeah, that's what it says.
So the prime purpose of the designation is to conserve and enhance the natural and scenic beauty of the landscape. It's the first paragraph.
So in the blue box at the top, the aim, I've just read to you that I've said that the setting is given national importance within that aim, isn't it?
Sorry, I'm trying to get the whole. Yes, the aim, new development enhances the local character and the environment quality of its national importance setting.
And
nationally
then,
important setting.
Thank you. And then can I just ask you to have a quick look at, again, we're in CDB. So if you turn to CD8B.2, CD8B.2. That's the landscape proof of evidence.
Okay.
And when you're there, if you turn to PDF page 26, please.
(26), yes.
And you see there we've got paragraphs 4.27 to 4.29. Now, you're aware that Mr. Dudley took the relationship with the national landscape as one of the receptors that he assessed when he was carrying out his LVIA. Do you remember that?
I do remember that, yeah.
And when one looks at 4.28, you can see he identifies, in terms of the location, the alignment of the site perpendicular to the existing Lydia Park boundary means the separation between the residential gypsy and traveller pitches uses, and the A&B would be substantially reduced from approximately 300 metres to 160 metres. And then at 429, he goes on to discuss the relationship. Now, in respect of the location perpendicular to the Lydia Park boundary and the reduction in distance from the boundary, those are plainly relevant factors when looking at the degree of impact the development is going to have, aren't they?
Possibly. You need to assess it on the ground and visualities from public areas, and it could be, and I think it is, the fact that because the land slopes up towards Lydia Park, that the existing gypsy and traveller sites have a greater impact on the national landscape.
And that's the purpose of landscape assessment, isn't it? To determine what the impact is by looking at the magnitude of change and the sensitivity of the receptor.
but
That's right, isn't it?
But the point is, yes, but the point is, just because the distance between the national landscape and any of the traveller pictures has reduced, doesn't mean to say per se that that's going to have a greater impact.
No, it's a matter of, it's a relevant factor that's part of the assessment, and you can draw a conclusion based upon that assessment, don't you? And that's what the inspector's going to have to do.
Well, the inspector is going to come to his own decision based on the evidence and what he sees on the ground.
So the next thing I want to just move on to, I'm conscious of the time, is the issue of impact on settled community. So a separate topic. And I want to start by just asking you to have a quick look at the PPTS paragraph 14, please, wherever you've got the PPTS.
Paragraph 14, yeah?
Yeah. And we can see there that when assessing the suitability of sites in rural or semi-rural settings, local planning authorities should ensure that the scale, Mr. Masters reminded you, underline scale of such sites does not dominate the nearest settled community. So first things first, well, that's clearly a part of the BPTS, isn't it? The policy that needs to be applied.
Yes, it is, yes.
And that paragraph is directing us to consider issues of scale when looking at whether or not there's domination of the nearest settled community, isn't it? So scale is clearly important.
That's what it says, yes.
It doesn't say anywhere, and you've not sought to suggest anywhere that I've seen, that scale is limited to impact on services. You don't say that or provide an authority to that to support that proposition, do you?
Sorry, I don't understand.
You don't say that considerations of scale are limited to impact on services anywhere, do you?
Impact on services? No.
No. So scale can be spatial extent of something. It doesn't have to be services impact, does it?
Not. It's not what the paragraph says. It's not to do with services as such.
And in terms of the decision we've got from the inspector, sister inspector, in respect of the other site, can I just ask you to quickly turn that up? Again, Inspector, really, I'm just looking at this stage to identify matters of approach. And I just want to look at 3A.8 again, please, Mr. Woods, just so I can see that we're on the same page. So 3A.8.
Sorry, CD
3A.8.
I don't have 3A. I've CD 3B.
So if you close down 3B, I've got it
have,
open
yeah.
in 3A.8. So go to the A file of documents.
Well, the next content above that is CD 2B.
So you want to go above that to the top of B and then close B down and then open up A.
Oh, sorry.
Yeah.
Okay. CD 3A, yes?
You've got it. Yeah.
Thank
Brilliant. And then we're on PDF page 4 when you've got that open.
So is it 3D, CD 3A1?
CD 3A.4.
Point 4,
And it's,
Appendix 3, yes?
well, I've got it open now, so I'll go back in to see. It's just three, it just says CD 3A.8. Yeah, 0.8 it is.
Oh, right, okay. Go back.
So appendix
Point 8,
6.
Appendix 6.
6. You've got it. Yeah, brilliant.
Right.
And then PDF page 4.
Okay.
So on that page, we can see there that Inspector Gilbert was looking at, under paragraph 20, this issue that she introduced about domination of the nearest settled community. And we can see there in paragraph 20 that she considers 6 lines down, both that it would numerically increase the existing dominance, but then spatially, the extent of land occupied would also increase, despite the site's location on the far side of Lydia Park from the settled community. So she's looking at numerically, but she's also looking at spatial considerations there, as we discussed before, isn't she?
Yes, she is. And she's looking about the 4 extra pitches. But since then, the council have granted 5 extra pitches of Lydia Park.
And
so, you know, it's, you're saying that, oh, because she says that, then that's fine. That's what we're latching onto. But you've subsequently granted planning permission for more.
well, let's explore that. And if you go back to PDF page 3 and just have a look at paragraph 13.
Sorry.
Paragraph 13, Inspector.
Yeah.
Starting, my attention has been drawn.
Yes.
So you see that really dealing with your point, Mr. Wood. She says, my attention has been drawn to 3 recent planning permissions for sites on Lydia Park to the south and the refusal of a further site to the west. The southern sites were approved by the council on the basis that they would infill existing gaps between other gypsy and traveller sites. I saw from my site visit that there's some activity on these sites, although not all of them have been implemented as yet. The sites to the south would have a smaller and generally rectangular pitches with limited landscaping. And then this is the bit I want you to apply your mind to. While they would be likely to be more intensely occupied than the proposal due to their size and layout, their infill position to the south of the track within the established area of Lydia Park fundamentally differentiates them from the proposal before me. So the question for you is that, yes, sites have been granted permission to the south, but when looking at spatial considerations, this inspector viewed the fact that those sites were south of the track as being fundamentally different from what was before her to the north, didn't she?
Yes, she did. But that's a different point from the domination. That's to do with a landscaping impact. She's saying that the sites that have been granted planning, but she's got very limited landscaping, which, you know, could be different from that appeal proposal. I don't know what they proposed in detail, but in terms of the current appeal proposals, which we've talked about landscaping, we have a session on conditions that deals with that matter.
So your view, the way you've assessed impact on the settled community and spatial considerations is on the basis that that paragraph 13, doesn't relate to whether or not something is positioned spatially to dominate the settled community. You view that as relating solely to landscaping considerations.
I do, yeah.
Yeah, okay. So in your view, then there's no difference in terms of spatial domination between something being situated above the access track and below the access track. That's correct, isn't it?
Well, I mean, the spatial domination It's really in terms of going back to what the PPTS is talking about. It's talking about numerically in terms of numbers, not really spatial, because you could have a very big site of 3 hectares, and there'd be one pitch within it, in a small part of it. So I think it's not comparing like with like.
All right, so I'm going to move on to the second consideration then, which is that before we can decide whether or not we've got domination of the nearest settled community, we have to identify, don't we, the nearest settled community. And what the inspector has taken as being the nearest settled community in this case is obviously the community around the 20 or so dwellings around Stovolds Hill and Thatched House Farm, isn't it? That's what she's taken.
That's what she's taken to, but
Yeah.
that's
And you
not my
disagree with
view.
that?
Yeah.
But in terms of the reason why you disagree with it, you say, well, the Dunsfold Aerodrome development should be included within the nearest settled community. But it's right, isn't it, that that's not physically there yet, is it?
No, but as I've said on a number of occasions, all the infrastructure's in and the houses will be built. And so therefore, that is part of the nearest settled community. It's been granted a planning permission. It's been allocated in a local plan. It's got certainty.
And in terms of the way that let me just ask you to turn up CD 10A.5. So CD 10A.5.
Yes.
And go to Appendix 18, so the last link within that part of the documents. So Appendix CW18.
Yes.
Yeah, that's right, Inspector. And then if we go to PDF page 14 and paragraph 64.
Yes.
So we can see that in relation to the supply of housing, the inspector in this appeal is looking at Dunsfold Aerodrome. And it's right, isn't he, that he concludes at the end of that paragraph, the site lacks the necessary clear evidence to be considered deliverable. Yeah.
At that point in time, that's correct. But it's moved on since then.
But as you've accepted, it's still not built.
No, it's not built, but that was an outline application. And since then, they've got the details and the road has gone in, the landscaping's gone in, and the houses will be built. And the way it works in terms of a housing site is that you have units. So you might have Crest Nicholson 60 units a year, you might have Gleeson 60 units a year, and it'll be split up. Well, it doesn't take much of that before you get to the amount of, you take that in account of the other houses, and therefore the appeal sites would not dominate the nearest settled community.
All right. And then I want to move on to the exception test that we haven't discussed yet, the part we haven't discussed, which is wider sustainability benefits to the community. And what I want you to do, please, is to have a look at the framework again and have a look at paragraph 178 of the framework, which is page 51.
You give me the honours on that, so I've got the right paragraph.
you think you could highlight it again?
I expected it to be in here, but it's not, is it?
Yeah. Brilliant.
Unmarked.
So we look at paragraph 178. We can see there, can't we, that to pass the exception test, it should be demonstrated that, and then it's little a we're looking at. The development should provide wider sustainability benefits to the community that outweigh the flood risk. Yeah.
Yes.
And in terms of those wider sustainability benefits, they can obviously be community matters that relate to flooding or ones that relate not to flooding, can't they? It doesn't have to relate to flooding.
No, no. I mean, it can be in terms of what we're suggesting about improving things for the wider community by reinstatement of the ditch, allowing the water to flow in that way. That has wider sustainability benefits for the nearby residents, and also sustainability benefits would be of the appellants having a settled base and the community knowing where sites are going to be, rather than having a policy where, in terms of meeting the need, we don't know where the need is going to be met. So it would be helpful to the community to have sites that are properly developed to meet the need.
So,
and then there won't be the need, then there won't be reasonable excuses for persons to move on to sites without planning permission.
so in terms of the approach that the inspector needs to take, he needs to, when considering whether there are, firstly, wider sustainability benefits as the first part of the test in A, he needs to look at community matters that may be positive and negative and come to a view as to whether there exist wider sustainability benefits as part of that definition, doesn't he? He needs to look at that picture first.
As I said, yes.
And then when he's considered whether or not taking things in the round there are wider sustainability benefits, it would only be if those benefits are obviously positive that one would come on to the next stage of the test to see whether they outweigh the flood risk, wouldn't it? So you assume he's arrived at the consideration that the wider sustainability benefits are positive, yeah?
Yes, you're looking at B next.
Well, before we go on to B, assuming that they're positive benefits, we then got to move on to the next step, which is, do they outweigh the flood risk, don't they? So he then needs to perform that exercise, decide whether those wider sustainability benefits, if there are any, outweigh the flood risk. That's the next step, isn't it?
Well, the step is looking at A and B in paragraph 178.
Yeah.
There's an and after A.
No, but yes, there is. But in terms of A, just within A,
Yes.
if he said, well, I do think on balance there are wider sustainability benefits.
Yes.
He doesn't stop there, because those wider sustainability benefits need to be sufficient to outweigh the flood risk. Do you see that it continues on, that outweigh the flood risk?
Yes, I do see that, and I've explained the flood risk relates to surface water, and the flood risk has occurred because of the filling in of the ditch. So the way that can be resolved is...
I think, Mr. Wood, you're being asked a point of principle as to how the test should be approached.
Yes, well, it says that development provide wider sustainable benefits to the community that outweigh the flood risk. And I'm saying it will be outweighed because of what is being proposed.
And that is an assessment the inspector needs to perform by considering what the flood risk is and how serious it is, because that's obviously relevant to whether it can be outweighed by any
Yes,
benefits.
of course, yeah.
So the next question then is, in terms of sustainability, Not sustainability in terms of flooding or all those matters we've already looked at, but sustainability in terms of transport, essentially,
Oh, right,
connectivity.
yes.
Now, I don't read you as saying that this is something which is either positive or negative within your evidence. I see you as saying this is something which is essentially neutral because it's not a reason for refusal. Have I got that right? That you see it as being basically, we haven't said it's a reason for refusal, it's something which is neutral.
Well, we shouldn't be discussing it then. It's not a reason for refusal, so I haven't turned my mind to that because it's not something that's necessary. But in terms of sustainability of the location of the traveller sites, well, clearly your council find this location to be acceptable for sustainability reasons for traveller sites.
So I'm happy with your answer, Mr. Woods, on that. So moving then on to best interest of the child, and really I'm not going to put this to you over and over again, and I don't want to put flooding matters to you again. So I'll just put it in terms of one of the sites you're dealing with, site A. And on the basis that the design flood event shows more than 2 feet of water across that site, do you still maintain in those circumstances that it's in the best interests of the child to be on
Which site?
site A?
Okay.
Do you still
Well, the-
maintain that it's
Well,
within
the
best
wrong
interests?
data has been taken.
Well,
It's proved to be incorrect when you look at the aerial photographs, when you look at the mapping, it's proved to be incorrect.
So
I don't accept that.
All
no.
right, so I'll put it a hypothetical question. If the inspector were persuaded that in the design flood event, there would be more than 2 feet of water across site A, would you then still say it was in the best interest of the child to be on that site, given the circumstances of this particular child that we've heard, or not?
Well, I think the surface water flood event, it's not a fluvial thing, it's a surface water flood event, will be limited in duration. And the occupants can stay safe in their caravans.
Thank you very much. Well, in light of that answer, I'm not going to put anything else to you on that. And then the final point, Inspector, is this, intentional and unauthorised development. So I listened carefully to what you said in respect to my learned friend's questions. And the starting point for intentional and authorised development, can I ask you again, just to have a quick look at the framework and paragraph 7. So on page 6 on page 4. In the framework, page 4, paragraph 6. So we can see there, can't we, that, and I don't see you as disputing this, that written ministerial statements such as that relating to IUD, that's obviously a relevant consideration. And you and I have discussed it, obviously, lots of times. So you don't say it's irrelevant.
No, I don't say it's irrelevant. It's a consideration that needs to be taken into account. But in terms of the weight you put on it depends, in my opinion, to the harm that has been caused.
So, and this is what I want
whether
you
it's
to,
reversible or not.
this is what I want you to think carefully about. So we're dealing with intentional unauthorised development. Now, what you said in answer to my learned friend's questions was that if it wasn't your applicants who had done all of the development, those elements that had been done by someone else, that wouldn't be relevant to intentional unauthorised development. Is that your position?
I did say that, and that I stand by that, because if it's something someone else did and there's nothing to do with the appellant, then it shouldn't be held against them.
But it's still an authorised development, whoever's done it.
Unauthorised development is carried out by someone else and not the appellant.
So why, if the inspector is being asked to grant permission for the development, why should he exclude elements relating to parts of the development that have been done by someone else?
because it's nothing to do with the appellant. It should, in the appeal process, it's looking at it, intentional and unauthorised development, and what you have done. And what they have done is not the cutting down of trees and is not the placing of harm standing. Nothing to do with them.
Can you point to any document or any decision or policy that says that when the inspector is deciding how much weight to give to intentional and authorised development, he should only consider the specific acts done by the applicant that he's considering permission for?
Well, I think it's a common sense approach that you shouldn't be hoisted by the petard of what someone else has done. It was nothing to do with you. I had it in a case in Plotlands where there was previous hard standing placed on the site. The appellant bought the site. There was a tree on the site, a single oak tree, I believe it was, and the oak tree had been cut down by him, unbeknown to him, or indeed the council, when they took enforcement action, was that the tree was covered by a tree preservation order. Now, he should have, I suppose, known that when he purchased the site, because it would have come up in the land charge search, but the council weren't aware of it, didn't feature in their enforcement notice, but that was the reason he lost the appeal, because that was the intentional and unauthorised development he did, and not putting down the hard standing, which was someone else.
So I've noted down what you said in your chief on this, and you said, quote, "It will be a different matter if they did it." So am I right in thinking then that you accept that this would be a serious case of intentional and authorised development if your particular applicants, and I'm talking about A and B obviously here because they're who you represent, had carried out all of the actions? But you say, well, they haven't carried out all of them, and that's the reason why it's not so serious. Is that a fair summary?
I think you're putting words into my mouth about it being serious. I don't know what the situation was before, and we got some aerial photographs, but aerial photographs purporting to show trees might be scrub. So I don't know the extent of that there. Yes, hard standing has been put down by someone else, but it wasn't by the appellant.
Mm-hmm. So, but I'm asking you specifically about those words, a different matter if they do it. Would it be fair to say that you accept it would be more serious in your view if they had done it?
Yes.
Inspector, those are all the questions I have. Thank you.
Just a word of information, I do have a decision where the development had been carried out by someone else, and the inspector said the appellant did not carry out these works. It is clear that they do not amount to IUD by the appellant. And that was a decision in Wickford, Essex, in which my own friend Mr. Masters and Mr. Wood were both involved.
So Steve, the convention is if you want to put evidence in, you don't do it after somebody's given their evidence, Stephen. So, well, he hasn't referred to.
I'm sorry, Mr. Cox. This matter's been mentioned several times. It's rather late in the day to suddenly start mentioning it now after cross-examination's taken place.
I mentioned that is the case.
So I think Mr. Wood had already referred to that case.
Well, if he had, there was the opportunity to mention the document then and to ask for it to be submitted. It's being mentioned now rather after the event.
I was about to do that, so I apologise. But I was about to suggest that we submit the document.
Well, I object to that,
So
and
do
I
I.
will make submissions on intentional authorised development based upon the evidence, Inspector.
Do we have a copy? Right, what I'll do is I'll simply have a copy tomorrow and then put it forward to you and want to accept it.
I've already indicated, Mr. Masters, at this stage of proceedings, after the questions have been put.
You don't want it?
I don't want it, no.
Then I'll leave it. Sorry, I haven't realised it's been indicated.
I mean, I was referring to it, sir, in answer to the questions in cross-examination.
Yeah. Mr. Woods, there's just one thing I'd like to ask you about, please.
So,
And you've been asked quite a number of questions, both in chief, I think mainly by Mr. Masters and by Mr. Lintott in cross-examination, about the point in the PPTS concerning the nearest settled community
oh yes, yeah.
and question of dominance. Is there a difference between a settled community and a settlement?
Well, I've looked at that myself on a number of occasions. And
Yes.
We're relating to Headcorn in Maidstone.
Yeah.
What happened is very similar to this case, actually.
Yes.
Very similar in terms of scattered dwellings around the appeal site, not even considered to be a hamlet. So I think the nearest settled community would need to be more than just a few scattered dwellings. You need to go further than that. So.
Yes. And what's the answer to my question? Is there a difference between a settled community and a settlement?
Well, yes. Yes and no. There may be or may not. It really depends on the merits of individual cases. You may have a settlement defined in a local plan,
Yes.
but there may be a hamlet that's 30 houses, but not defined as a settlement. I don't think there's a definitive answer, really, sir.
Well, the reason I ask is that settlements are often mentioned in local plans.
Mm.
The PPTS chooses a different form of words. I think it's in policy C, refers to a settled community. So in the example you were just referring to, where there's, say, a hamlet of about 30 dwellings,
Mm.
he's suggesting that could be a settled community.
Could be, yes.
And could that be sufficient in its own right? A hamlet of about 30 dwellings?
Sufficient in its own right
Yes, if it
to comprise the.
a settled community.
Well, I think it's not necessarily on its own. It may be other houses that are in that area. It might be part of the houses that are in the parish. We've
Yes.
looked at it in ways like that beforehand. So that's another way to look at it. The settled community in this parish. So here we've got two parishes, of course, but you know it's wider than scattered dwellings around a site.
If it's wider than scattered dwellings around a site, what would you regard, say, as a minimum threshold?
Well, as I said, what we've dealt with on a number of cases is you look at the parish, and that's an appropriate way of doing it. So you might have a parish of 300, 400 dwellings. I'm sure the parish consider themselves to be a community.
And do I take it from your answers and that you regard the settled community as something distinct from a settlement?
Yes.
Yeah. Thank you, Mr Woods.
So,
Councillor Sullivan, are there any questions on behalf of the parishes for Mr Woods? Sorry? Do you want to come down to a microphone, please?
Sorry, Mr Woods, can we go back to right at the beginning of your afternoon session? And in the afternoon session, you said if Pollingford Place at Ellen's Green is near to a national landscape designation, how far away do you think it is compared to Stovolds Hill?
I don't know, I haven't got the answer in front of me. I could find it in the decision letter, but you obviously know, so perhaps you can tell me.
Well, within the South Downs National Park, it's 15 kilometres. From the Surrey Hills National Landscape, which is the one that we're talking about today, it's only 8 kilometres, whereas Stovolds Hill is 195 metres. So there's a big difference between...
There is a difference in terms of distances, but it's the relationship of the site to the natural landscape. You're looking directly down upon it.
Okay, one other tiny question then. Does planning have regard for the impact of this site at night? So the fencing that's around these appeal sites has a number of little lights all the way around them that are light at night. In planning terms, how will this be dealt with in future?
Very good point. And what should be designed is a lighting scheme, which will be part of the site development scheme, that doesn't illuminate the sky, but downwards, because it has a number of things, as well as residents seeing its dark sky and seeing all the lighting up there, but also relating to bats and foraging. Better to have lighting that goes down so it's not impinging in that area. So it can properly be dealt with in the site development scheme.
Okay, then another very, very tiny question then, case law. Do you take this into consideration when it comes to the effect of a development outside the Surrey Hills National Landscape? For example, Guildford Borough Council had one in 2025, February decision, that showed the effect of a development that's outside the national landscape, but it has an effect on the Surrey Hills National Landscape itself. So it's just a little point that I'm trying to make to you. Was it something that you take into account or not?
I'm not sure I understand the question. You're referring to Guildford?
I think Councillor Sullivan's asking about effect in relation to setting. That's how I understand the question.
Oh, right, okay.
Yes.
Yes, I mean, certainly that's part of what we look at and what we're advocating in terms of conditions for having a planting scheme. So if you go beyond the appeal site and go to the road that's at the end, and if you happen to walk along there, I suppose, or stop there in your car looking up, you would have a hedgerow, and then we will propose a new hedgerow and planting. So yes, that sort of impact has been taken into account.
Great, thank you very much. And those are the only 3 little questions that I have.
Okay.
Could I just add as a point of information regarding the presence of night lights around the surround of my side? I'm instructed they aren't there. You can have a look for them tomorrow on the site inspection. But whatever you're talking about, it's not Appeal B.
Okay. Thanks, Mr Cottle. Thank you, Councillor Sullivan. Mr Woods.
So
Mr Masters. I'm sure you do, Mr Masters. I would be surprised if you didn't, but I'm going to take a break first. Yeah. It is.
Switched off the fan, I think switched off the air conditioning.
Well,
Yes, that'd be good, yeah.
yeah. I'm content with where we're up to, so I think I'll take 15 minutes and give the aircon chance to do its work. So we'll adjourn now, please, and resume at 5 to 4.
So.
Thank you. Five two, Mr. Linton. Yeah. It is. Time to resume. Mr. Masters, you said you had re-examination of Mr. Woods.
And I think I'll just get it up if I can for a second. Paragraph 14 of the PPTS. The inspector asked you various questions on it, and I just want to re-examine
Yes.
on it.
Try and find it first. Have you got a CD number?
It's the
Was the inquiry
PPTS.
document?
It's a PPTS, Mr. Woods.
I understand that.
Yes, sorry.
Where can I find it, please?
Have my copy.
Thank you. Paragraph 14, yes?
Okay. So there's a reference there to the nearest settled community. Can I ask you this first? Do you regard the scattered hamlets in Stovolds Hill that are referred to in the decision of the inspector, I've forgotten the name of the inspector, Gilbert, thank you, I'm very grateful, to come within that definition?
No, I don't.
If we're talking about a settled community in Stovolds Hill, what would you regard as the settled community? The gypsy community, or a mixture of the gypsy community and the hamlets, or what?
Well, the character of the area is a mixture of caravans and dwellings.
You remember that document that the parish council produced of relation to reports of various events that had occurred?
Oh, yes, yes.
And do you remember when I asked the parish council whether or not that differentiated between the hamlets of the settled people and the gypsies and travellers? They said it didn't, it covered both.
No, just a series of incidents, yes.
Yes. So it's always very difficult in these cases. Should you read into that definition a reference to settled as opposed to travelling people?
Well, I think that's what it's referring to, because it's the planning policy for traveller sites document. And it says, when assessing the suitability of sites in rural, semi-rural settings, local planning authorities should ensure the scale of each such site does not dominate the nearest settled community. So they're not referring in that document to gypsies and travellers as being the nearest settled community.
Okay. The reference to community is that, in your view, an important reference in the way that you should look at what that paragraph is referring to, or not?
Well, it's referring to the domination of the nearest settled community. And I say the nearest settled community, the proper way of assessing it probably is by a parish, not by dwellings that are just in Stovolds Hill.
If you interpreted that literally to mean a few scattered dwellings, would that be operationally an appropriate way of the PPTS working? In other words, a few scattered dwellings could stop a gypsy site because that gypsy site was, say, slightly larger than a few scattered dwellings.
No, I think that'd be the wrong approach.
And I've already asked you this, but I'm going to come back to you. When the inspector looks at this, does he have to interpret this in the context of a public sector equality duty, Article 14 of the Convention, and
I
whether
ask no questions on that, Inspector.
and whether a policy operates? I know, but the inspector's come back on it, and so therefore I'm entitled to ask.
Well,
whether-
if you've already asked it, there's no point.
Well, let me just finish that. You've heard the inspector's questioning on that. Has your answer in relation to that remained the same or not?
Well, you need to have account of the public sector equality duty.
And does it appear whether Inspector Gilbert had any account of those duties at all?
It would appear not.
Thank you. We could look at paragraph 232 of the MPPF. I'll read it out to you.
Yeah.
However, existing policies should not be considered out of date simply because they were adopted or made prior to the publication of the framework. Due weight should be given to them according to their degree of consistency with this framework. The closer the policies in the plan to the policy framework, the greater weight may be given. I just want to ask you about the policy that Mr. Dudley took you to when you were cross-examined on, and that's relates to AGLV and its policy RE3. What?
Who took him to RE3 just now?
I said he was cross-examined on.
Sorry, my
Which-
mistake.
No, Mr. Dudley, no. Two things. Mr. Dudley did take him there, and he was cross-examined on it, and that's what I said. I don't know if we can record the thing to see, but that's what I said. It's okay, don't worry. Not that it matters very much, but if we look at that, we know that the way that that policy is framed was in the context of the retention of the AGLVs while the process of whether or not they were going to be included in the then ANOBs, now National Landscape, was being reviewed.
Well, when the policy was in inception, there wasn't a review going to be taking place. So then the review's taking place, and clearly that policy, that part of the policy should have lesser weight, because looking at candidate areas, the AGLV to go in the national landscape, and the appeal site is not one of them. We know that, so it's not going to be in the national landscape.
So I'm going to read policy RE3 because of that it does state what I said. I'll read it to you. The area of great landscape value, this is little Roman numeral 2, sir. The same principles for protecting the ANOB, national landscape now, will apply in the areas of great landscape value, AGLV, which will be retained for its own sake as a buffer to the ANOB until there is a review of the Surrey Hills ANOB boundary, whilst recognising the protection of the OG is commensurate with its status as a landscape designation. And let me just read it to you again, because the important words there.
Yeah, I hadn't realised the review had been going on for so many years, to be honest.
Yeah, but it will be retained in its own right as a buffer until there is a review. Okay, so it's quite clear that there's been a review.
Yes.
Okay, and now does the policy now apply to it in your view? In connection with how the inspector should interpret it in accordance with paragraph 232?
Well, no, because we know that the appeal site would not be incorporated into the natural landscape, so it should no longer have that effect.
Thank you. So we know that the AGLV is a local designation. We know the purpose for it has gone. So what weight do you say the inspector should now give to it in the context of this site?
Limited weight, it's part of the countryside.
Thank you. And if we could then look at the MPPF at 178. And remember, there was a long exchange between you and Mr. Lintoff about surface water flooding, about flood risk, about the approach to be taken to the blocking up of the
The ditch.
the ditch, thank you, and the raising of the levels. And I'd like to look at that in the context of the exception test at 178. Okay.
Okay.
And could I ask you just to look at 178A? And I'll read it out to you again.
If you can, because
Okay. I
haven't
know,
got it
I
in front of me,
understand, I
because the
understand.
online version is the wrong version.
Okay. 178A says the development will provide wider sustainability benefits for the community that outweigh the flood risk. Now, is that referring to the actual flood risk, or is that referring to what once work has been identified to do it, or is that referring to something else?
Well, that is referring to if there is a flood risk. And as I said, the appeal site will not flood if the ditch is reinstated.
So your position is?
Sorry, Mr. Woods, I missed the end
Yeah.
part of what you said.
So whilst there is a flood risk because the ditch is infilled, once the ditch is reinstated by virtue of a planning condition, if appeal is allowed, then that will mean that the site will not be subject to flooding. Because that was the situation prior to the ditch being infilled. We see that from the plans and flooding information.
So if the inspector comes to the conclusion that the problem here is the filling in of the ditches and the raising of the levels, and if that was to be rectified, there'd be no flood risk. Would the sustainability, wider sustainability benefits under 178A be in play if there is no flood risk?
It will not be in conflict with that anymore, no.
Thank you. I've no further questions.
Thank you, Mr. Masters. Mr. Gottle, have you any re-examination?
No further re-examination.
Thank you.
Understatement.
Something just message, that's all. Are you all okay?
No,
Not really, no.
Yes.
Wait.
It's the balance between the vineyards and the heat.
Yeah.
Yeah, it was get probably noisier.
Yeah.
Yeah, we'd like it noisier, yeah.
Yeah, I think we would now, Inspector, unless you really feel that if we can't bellow over it, I think we ought to have some air conditioning on.
Yeah, if that's the consensus, I'm happy to go along with it.
Yeah.
But I may have to ask people to repeat themselves. I'd assumed it was back on because I can definitely hear a background
I
noise.
can do
I
that.
think that's a fan that's on somewhere actually, so I
Right.
think it's going to get, yeah.
Oh, right, okay.
So could I ask that we just take a very short break for my convenience before we go on to conditions?
Yeah. Yes, I don't. In fact, before we do it, I'll do that, Mr. Masters. Can I just ask, so that I have an idea of what I'm going to be saying to you later on. Just a few questions. Well, at the outset of this inquiry, I asked for an indication of any likely cost applications, and at the time it was thought there would be none. I just want an update on that so I can think ahead for tomorrow. Right.
No, I've got no instruction.
Mr.
No, we're not.
Thank you very much. Okay, and the other thing that would help me would be an approximate indication of time for closing submissions. Mr. Lintott, what do you reckon?
About an hour and a half.
And do who's going first?
I'm happy to go on appeal B about an hour and a half too.
An hour.
Okay, that's very helpful. It's just gone 10 past, back at 20 past. Does that give you sufficient time?
Thank you, sir. Just,
Yeah. Okay, we'll adjourn and be back shortly, please. 20 past 4.
I can check. I don't think it is. Yeah, let's have a look. Yeah, yeah.
Just wanted to refer to this if I could. But it shows the extension just to the inspector's cottage.
Right.
And I don't know whether it's in or not. But I've had it since the Mr. Ward says he's got it. I can't establish that it's actually building.
Well, I don't think it is. I mean, I can have a look, but
Whether we would object. I just think it's a matter of record. So because I didn't put that, I thought we had this discussion within the 24. I put the sticker on it, it's somebody else. I think this was up in front of it, somebody. It was something we were discussing.
I don't know. I mean, at this stage, I'm sorry, Stephen, I can't remember. So it's just that none of the witnesses have referred to it. I think. I mean, if you can find that it's been discussed in the evidence, then no. But if it,
I think I've just said that's how I just said.
okay.
You don't actually think stones.
Well, I would need to take instructions from Ian. So, Chris, what I've said is that I would need to take instructions from Ian if it's not been mentioned in the evidence. Yeah. So I need to look and see. So if it's been mentioned and he's asked questions about it, then that's fine. But if he hasn't, then
want to get this to respect it because it shows the deletions and the additions. It's just a matter of record.
Yes, yes,
Very good. Very good. Thing in this thing is that when I was talking about negative grampians,
yeah.
it's on the basis that they might fail to make a strategy worked out. But that's the whole point about putting in it.
Yes, true.
Yes, it's meant to have teeth.
Yeah, yeah.
And we will die by it,
Yes.
if we don't succeed. But it's perfectly possible for them to do it.
Yeah. Yeah, fair point.
That's the surface dream.
Have you've got this, haven't you?
Yeah, that's
Your
right.
22nd, yeah, yeah. It's those there, or if it goes in the site development scheme.
Yeah.
Those there.
Well, I'll let you.
Well, yeah.
Most of it.
On me.
Right, time to resume for the roundtable on possible conditions. Councillor Sullivan, there's the opportunity for you to comment on conditions as well if you wish. Just in case you do, would you like to come down, please, and find a seat where there's a microphone handy? The way I propose to do this is to take two documents as my points of reference. Firstly, I've got the suggested conditions that were put in earlier on in the inquiry by the local planning authority. And recently I've had comments from Mr. Wood's firm on those conditions, which I'll refer to those side by side. And then there may be some additional points as well. Mr. Bennett, are you taking part in this session?
Yes, possibly.
It's fine.
Sorry, sir, the confusion then, I think it was mentioned earlier, you said you'd had the appellant's response to the conditions. I've not seen that, so.
Yes, I'll tell you, let me just see where it was sent.
Like latest version was on the 22nd of this month. It was sent to the council.
Sorry, that's a different document.
Circulated.
That's yesterday, 22nd.
Yes, Mr. Woods is correct. It was sent. Let's see where it went to. It's been sent to the council. It was sent yesterday at 5:15. So late in the day, but and it was sent to the parishes as well. Hopefully, Mr. Bennett and Mr. Ward, if I explain exactly what's in it as we go along, we can deal with it. Yeah. What it is, it's an email with an attachment as a Word document with the.
No, so I've certainly not received it.
I'll tell you where it was sent. It was sent to you. It was sent to yourself, Mr. Bennett.
Oh, okay. Well, I better check my junk folder then.
And Victoria Charlton.
Yes, that's right.
Yeah, they usually are. It's unusual that I wouldn't receive.
And
be copied in.
consultation planning.
Yeah, that's the usual. It must be my end then, so I'll check my junk folder.
No sign of it, Mr. Bennett. Well, yeah. Well, let's see if we can make progress. I can take it slowly if you need to check it, anything. In the first, what I propose to do is the suggested conditions, they're not identical, but they're very similar in respect of the 4 appeals. So I intend to work from appeal A. If there are variations and I don't mention them, whatever, please jump in and point it out to me, but I'll use A as the basis. So what I'll do, Councillor Sullivan, too, because I don't know whether you've seen these, is I'll explain what each condition is about as we go through it. And the first one on the council's list was simply to refer to the plans that were submitted to make sure that the development's carried out in accordance with those. And that's one that I would expect to see, and the appellants have no objection.
The only issue there, sir, in quick comparison, you've got a list of plans for A and B. Sadly, the list of plans is omitted from C and D. So we will need to give you, or we'll need to agree, a list of plans for C and D.
Right, okay. I think that's probably fairly straightforward because I don't think there were many.
It shouldn't be an issue, but I
No.
just don't, I've suddenly noticed it's not there now, so.
In fact, I think, notwithstanding that the proposals for C and D say that they include a day room, I've seen no plans of a day room for either of those sites. And I think the only plan that I'm aware of is the revised location plan, Now, I don't know whether, is that your understanding as well?
It is, but I think I ought to check.
Yeah, of course. Just while Mr. Ward's checking, the covering email from Mr. Brown John says that it's his understanding that Mr. Rowe, in respect of appeals C and D, shares the comments that have been submitted.
Yes, we had a short email from him, so.
Right,
so
good.
That's correct.
Yeah.
So just to confirm, we have been provided with those now. So
Sorry.
we've been provided with the conditions lists now.
Oh, you've got it.
So got those.
Good, good.
No, so it's helpful. I haven't got a copy of the day room here, even though I acknowledge it's actually shown on the block plan. There's one on it.
It's shown on the block plan. I don't think I've even got that.
Well, this isn't the latest block plan, but this is the original one.
But that'll show the wrong red edge, won't it? Because the problem we had with the plans was with sites C and D.
Looking for the block plans for C and D.
That's the original block plan, and that's the day room, isn't it?
Yeah.
Do you want to hold up the plan and show me?
If I'm,
Oh,
you
yeah.
go and read, but on that plan, which I think is the wrong one.
Yes.
But it's not the later one. We've got a mobile home for each block shown, and there is what seems to be a building there. And at small scale, you can see the room layout of what appears to be a day room. So but I haven't got plans of that built as a building.
Yeah. Mr. Masters, I'm really struggling because of the icon.
Sorry, no, it's my fault. I forgot to put the thing. I know that Mr. Rowe submitted amended plans
He
to
did.
cover an earlier complaint,
Yes.
and that's dealt with. My understanding, so the plan showed one mobile and one tour.
Well, the plan that Mr. Ward just held up, I do have that, and he's right. There is there's a layout on there, but it's in the wrong place. Because that was the reason for the revised plans being
Yep.
requested. So
In terms of the site is in the wrong place.
yes,
Yeah.
so clearly anything on the site is also in the wrong place, and that is what I have. So I've simply got a red edge, which I asked earlier on in this session of the inquiry whether that people were happy that was accurate, and you are. So we've got the location plan is fine, but that's the extent of the plans.
That's the extent of the drawings.
Yes.
Show me that drawing again. Yeah, you'll have the conditions.
Right.
The one that you should show.
Well, do you have that, Mr. Ward?
That didn't look like the one.
Nope.
It's in the evidence it's attached to the appendices of Mr. Rowe, but I don't quite know what
Oh, yes.
what it is.
I certainly don't have it here at the moment, so.
So there was a plan attached to Mr. Rowe's evidence,
Yes.
Appendix 2.
And does that give the missing information? Is that what you're saying?
I wish I was saying that, but I actually can't make head or tail of the plan. So I'm not sure it does. My view, sir, is that a site development scheme would be what I'd be proposing in any event.
Yes. But in terms of the plans we're talking about, I think that for C and D, it's simply a location plan. at the
It will
moment.
just be the location plan, I think, yes.
In terms of A, I've got a site plan and a location plan. Presume the party said those. And then in terms of B, I've got more. There's the, I haven't got a location. I have got a location plan. I've got a site plan. And I've also got a planting plan. And in view of the condition that's suggested, I just wondered what the party's views were on the planting plan, whether that is superseded by the condition or whether that should be specified. What's the thinking, Mr. Woods?
Whether the landscaping plan supersedes the earlier plan.
Whether it's superseded by the condition.
The landscaping plan is an illustrative plan of how it could be laid out.
So in terms of approval, site plan and location plan.
Yes, it's
And I've also got details of the day rooms as
Yeah.
well for field day.
Well,
So those sets of plans.
yes, there's 1, 2,
There should be
3,
four, I think.
4, 5, 6 plans.
Well, I've got location plan, proposed site plan, and 2 plans showing the 2 different day rooms.
Yes, there's a contract plan as well.
Sorry,
A contract plan.
a contract.
It's listed in the council's list.
There's a context plan. What's described as the context plan, I'm taking essentially as a location plan because it shows where the site is.
Yeah, it's down as 20 J3292.
I've got the one you want. Yes, the contract plan. It's a location plan.
Right, and then there's a site plan. The
Yes,
site plan
you-
says
quite
presumably
right,
the layout,
yeah.
isn't it?
Yes, location plan, site plan,
Yep.
and details of the day rooms.
Yes.
Good. Got that. Thank you. So the planting plans in effect superseded, but they were intended to be illustrative and superseded by a suggested condition.
Yes.
I should perhaps just point out for the benefits, particularly of Councillor Sullivan, that having this discussion doesn't mean that I've come to a view on the outcome of the appeals. It's just that I need to hear the views of the parties on conditions in the event that the appeals are allowed. Right, condition 2 is an occupancy condition requiring occupation be restricted to gypsies and travellers in accordance with the condition.
I see the note refers to the revised definition and I have no concern with that.
Yeah, that's right, because the one put in was the old one. Yeah, is that? Yep. And then condition 3, just stop me if there are any points you want to raise as I go through these, is a condition which concerns the number and type of caravans on each of the pictures. Now, for sites A, C and D, I think the position is the same. It's 1 mobile home or static and 1 tourer on each of those pictures. The position is different in relation to Field B, which is the larger site for 3 pitches. And what's been suggested there is 3 caravans and 3 tourists, 1 for each pitch. But the proposal for B is 4 touring caravans, and there's been no issue taken about that. So I think that should be reflected in the condition.
Issues. That's fine.
Yeah. Thank you. Condition 4 is a condition which would restrict, in effect, larger commercial vehicles from being kept from the site. No vehicle over 3.5 tons to be stationed. And the appellants are content with that. It's one that's often imposed. And then there are a series of conditions then, which in effect the appellants are making the same point about each of conditions 5 through to 8, making the point that they should be replaced by a condition suggesting a site development scheme.
Yes, sir.
And the conditions, first of all, the first one is to do with landscaping. The second one, number 6 on the list, is to do with external lighting, which has been mentioned today. The next one is a proposal for electric vehicle charging. And the last one is for surface water drainage.
Does that include the Lawn Hill decision?
Well, it does later on, where we say in terms of site development scheme, we've got a suggested format. But below that,
Yes. Well, certainly the approach I would expect to use would be that of a site development scheme with different parts along the lines that have been suggested.
and
it's rather a complicated arrangement, but essentially it makes what it does has the effect that has been mentioned during the course of the inquiry. If requirements aren't complied with, in effect, the permission falls away.
And we can't stay on the land.
Sorry, Mr.
Then we wouldn't be able to stay on the land. That's
Yes,
what happens.
that's the implication.
No planning permission.
Yeah.
Can't. The other point is that the landscaping and what you're just discussing could include this corridor of particular planting that the wood white butterfly finds favourable, which is the trefoil and the I've forgotten the name of it. The other plant that
Yes, there were two particular plant species.
That's right, and we're
Yes.
offering a corridor around the perimeter of the site.
That's right. That's right, and that brings to mind one of the points I was going to suggest. I think there was reference made at some point during the inquiry to mitigation in respect of the wood white butterfly and great crested newts. But are you anticipating that's dealt with by way of landscaping or some other measure?
Well, I was envisaging the mitigation scheme, the Lawn Hill, is what Mr. Woods was referring to coming in. That's got the refugia for the greater crested newts, these little stone structures that they can go to.
yes, I mean, it's a separate
Condition, Mr. Woods.
a separate condition, really. Well, it could be included within that, I would imagine, but
Well, it could be a separate element of the site development scheme.
yes. I'm just trying to have a look to see how the inspector. And there's also the point about biodiversity, which would be the point that Mr. Cotter was just talking about.
In response to Mr. Cottrell's point in terms of simply landscaping, it clearly depends which direction you take on certain matters. But if, having heard the evidence, you consider landscaping ought to replace some of the habitats which are on site or woodland that was on site, then it would be helpful if that condition included including the replacement of 1, 2, 3, or a list of those features you would expect to see within the landscaping.
Well, subject to Mr. Woods correcting me, we open to any landscaping being as per the Robert Petro diagram.
Well, we're happy as that, but it was an illustrative plan. It's not
Yeah.
definitive. It's just demonstrating this is one way of achieving that. We show a hedgerow
Yes.
and we show a margin going round, so it effectively deals with those issues, but there may be particular points on it that the council don't like at this stage, but.
Yeah, I think my query is, if there are any points that relate to the species that have been particularly mentioned, do they need to be the subject of a separate limb to that condition, or can they be taken account of as within the landscaping proposal?
Personally, I think it's better if it's a separate point about biodiversity, because that's what we're talking about, isn't it, really, sir? Landscaping serves a slightly different purpose.
But are you suggesting a reference to biodiversity rather than the whitewood butterfly and?
Well, that will be part of the biodiversity. I think that's what it specifically.
I'm just thinking of the way the cases have been put at the inquiry. I mean, it's in terms of species and habitat for species. It's focused essentially on 2 species.
Yes. So the butterfly.
Yes.
So that will be the biodiversity specific for that.
Yes.
And then the Lawn Hill condition, which it was a standalone, but I think it could be part of the site development scheme. The inspector there said, before any further works take place on site, including hard standing or development, a precautionary Great Crested Newt method statement, including mitigation, shall be submitted to and approved in writing by the local planning authority. The measures shall be implemented in accordance with the approved details.
Is that before the inquiry, that decision, Mr. Woods?
That's inquiry document 18, sir.
Thank you. And presumably that approach to a method statement for the Great Crested Newt could be extended to the whitewood butterfly.
Oh, yes, that might be, yes. Yeah.
Just seems to me that it would be convenient to include both the species in one condition.
That would make sense, wouldn't it? Yeah.
What do you think, Mr. Ward, Mr.
I
Bennett?
haven't got the benefit of Mr. Sibbett here, but that makes sense.
Yeah.
The mitigation strategy that was attached to that decision, the quarry document 18, is also before you. The Arbtech one for that site. It's an earlier quarry document, the actual habitat plan.
Right, that's the condition concerning.
The one that was actually used.
Yes.
In the decision letter for the quarry document actually has, you know, just to see what it was like. You have it there, so you can see whether or not you're satisfied. You can see from that document whether you're satisfied it goes far enough. I'll give you the inquiry document reference, sir.
Yeah, please.
It's ID 7.5.
Thanks, Mr. Cottle, and that's the condition concerning drainage.
No, that is the
Oh.
actual mitigation plan attached
Oh,
to the
sorry.
decision letter in Inquiry Document 18 that was used.
Oh, right, yeah. And that was put in relation to an appeal decision that was already submitted. Yes, yeah. Okay. Yeah. And then there's the question of the drainage conditions. And then there's one that's suggested as an element of the site development scheme.
Have you seen it being used in other decisions? Have you seen it being used? in other decisions?
And then I've also had I've had separate versions put in as well. 3 options were submitted for surface water management. I think the appellant suggested that the favoured one was option 3. This is an email of the 6th of June last year.
Yes, that's what we considered, but the end of it needs to be the approved drainage scheme shall be implemented, and then you insert a time period rather than prior to first occupation. But then,
Yes.
then there's also the condition that could go in that we shown in red on the documents
Yes.
sent over to
Which
you.
I think covers the modelling.
It does refer to modelling. You're quite
Yeah.
right, Mr. Masters.
And I think that was the amendment was suggested so that,
Is that what you think would be preferable?
yeah, so that you have, I think that there was some, Mr. Smythe agreed that modelling as a first step and
Yes.
then a scheme based on that modelling would be the way forward.
Yes.
So that's the one line.
Yes, there still needs to be a slight modification because it's again refers to implementation before occupation, which clearly isn't the case. But it would, yeah, it would just have to be brought into
It would
line
just-
with the other elements.
Indeed. I'm grateful, sir.
I accept that point on the modelling.
Yes,
Usually less detail is supplied. It's just details to be submitted, but here we're going further.
yes.
Yes.
The council's well, sorry, so I'll wait my turn.
Yes, the opponents are suggesting put the section in red in E.
Well, my concern with that as written is it is a plot specific surface water mitigation measures.
No,
And you will clearly form a judgment, but the issues arise from, at least in part, from the loss of a watercourse, which is not plot specific.
Yeah, there is a reference to it should not materially increase surface water, flood risk elsewhere. But is your concern
The
about
issue
what-
is, and as I understood from part of the appellant's cases as they put it, is their starting point would potentially be the reinstatement of the ditch as it was pre-development, and that's pre-development on any of the sites. So in simple terms, we would be looking for a new ditch or a reinstated ditch from a point to the west of site A through to a point east of and probably beyond the access to sites C and D. Because without the reinstatement of that ditch in total, you do not have a flow of water.
Right.
That is the point about the negative Grampian, and we accept that the coherent drainage strategy does go beyond the actual junction of the appeal sites to Crocus Lane.
so we haven't any problem with that. I mean, that was the point of the modelling. It wasn't to model it on a site specific basis. It was to model effectively
Yes,
how best to reinstate the ditches where they've been
I
unreinstated.
think clearly a strategy could involve what you say, Mr. Ward, but I think your concern is that that should be specifically
The issue
mentioned.
is how each condition on each individual plot will achieve that overall objective.
But I think we could just put words into the modelling. The modelling would require consideration of the reinstatement of the ditches
Yes.
to the points referred to by Mr. Ward.
So you'd have no objection to a reference to reinstatement in the condition?
No, not at all. That's
What you're seeking, I think.
I think that's what we're seeking. My caveat on that, and it's if I properly understand the flooding evidence, and you've got various flood maps and submissions,
Yes.
is the flood mapping, as I understand it, still showed flooding in the event of the ditch as it was. So it needs to be a ditch, an improved version of the ditch to deal with flooding.
We agree with that. So I mean, that's part of our
Okay.
submissions. To the extent that that involves a Grampian position relating to those parts off site going down, we accept that, and that would be a condition that we'd have to
It was the
comply with.
position of Surrey, the lead local flood authority, that as long as the ditch is there and the
Yes.
channels are there.
I think this is Mr. Ward's point.
Yeah.
So he just wants the reassurance of a specific mention in relation to the ditch. Would you be content with that?
That's our case, yes.
Yeah. Good. So that could, as we mentioned with the mitigation, that could either be a standalone condition or part of the site development scheme.
Yes.
I think the reference point, so that will be more obvious to you when you've seen the site visit. So,
Yes.
you know, it's one of your issues to draw your attention to on site. And I think the intention is that you see both ends of the ditch as it is at the moment, and then draw your own view in terms of what needs to be done to secure that flow of water.
So obviously it would be a mirrored condition for each site, saying effectively the same thing, because obviously the modelling will cover the whole issue. But
Yes, I would
since
expect
you'll be
you to.
looking at each site separately, I mean, if there was some site you rejected for a reason, but then accepted the others, then the mirror condition would only apply to those you accept.
Yes. Yes, that's clear. Next one, I've dealt with the ones on the list that was circulated now, but there's also been mentioned by the appellants of the possibility of a condition relating to planning permission for a temporary period. I think Mr. Woods has given evidence of
So that's
3
put
years
in-
and 5 years.
Yeah, that's put in two ways, sir. If it was to give time for the PDA to come into effect and these other sites to come, we say 5 years. If it was based on a concern that a condition would not meet the flooding position, and you would prefer
Sorry, condition would,
not meet the condition would not meet the flooding concern,
yeah,
then we would say give us 3 years
yes,
to do the modelling and then resubmit.
yes.
That's how we put it, Mr. Woods.
I think that's how I recall it. Mr. Ward, do you have a view on a temporary permission? And
I think the concerns for a temporary permission are the same as for a full permission, other than the timescales it would take to actually do these works. But that depends on your justification, whether a temporary permission is justified or not.
yeah, well, if I were minded to grant a temporary permission, what's your view in terms of the length of time, having heard what Mr. Woods has said?
I think 3 years is probably the longest the council would look to. I can see it easily. I can recognise it would easily take 12 months, if not more, to actually address the flooding issue. So,
So you'd agree with Mr. Woods on that?
yes.
What about his view if it was a question of looking at alternative sites coming forward, perhaps via the PDA or a similar mechanism, and he suggested 5 years in that case?
My view based on 16B is that the alternative sites are there ready and waiting now, and it does not need the PDA for delivery.
Right, so no need then to consider 5 years?
No.
Then there's the question of the day room and materials. Now we've got site B. The application forms. There was a mention of I think in response to a question in chief about what the roof would be on the day rooms, and reference I think to corrugated material. The application form actually says tiles and solar panels for the roof and brick for the walls. Now the question is, should there be a condition requiring samples to come in of those materials?
I don't think there's any objection to those materials in principle, but yes,
Yeah.
I think the council would want a condition in terms of details of those materials to be agreed.
What do you think, Mr. Woods?
Yes. Sorry. Seems perfectly reasonable to suggest that details of materials, not necessarily samples, but details of
Yes.
them. And then regarding the day rooms, if you were minded to allow appeal B,
Yes.
you could do a split decision in relation to that. In that, well, yes, you don't accept it, for example, with the 3-day rooms, but you would accept it with the 1-day room.
I think from memory, we agree that it's the large day room that's wanted.
Yes, the large day room is the one that's wanted, so yes, correct. The L shape.
Yes, and that could perhaps be dealt with by way of a condition specifically
Hmm.
specifying that.
Well, I was just going to comment. I'm not sure if that is something you would condition, because presumably if you are minded to grant site B, but with only 1 day room,
Yes.
you will make that explicit in your decision that you're only granting permission for 1 day room, rather
Well,
than a condition.
It would come up in terms of conditions, Mr. Ward, because the condition referring to the plans would then not include the plan for the other day room.
I think the condition, I think, would need to refer to it, even if it was on the schedule of the
Yes.
condition saying for the day room in the northern position only, or however you would phrase it.
But the description of development would
Yeah.
need to be amended, and the condition would need to reflect that.
Yes.
Yes.
And then that leaves the question, I suppose this is, it's probably not really for you, Mr. Woods. It's site C and D, which must be Mr. Masters. And it's a question of what, if I were to find in favour of those appeals, which on paper are for included day room, but I have no details of the day room. Should that be excluded from the description of development, or should a condition simply say details of the day rooms to come in?
Well, I think you have both options. If you are unhappy with no details, you can exclude it, or you could have a condition saying details.
Yeah, I'd just like your view, and then I'll see what Mr. Ward says.
So I'm content to take the view that to exclude the day rooms.
Exclude.
Yep. If we get planning permission, and the site license, we can make an application for day rooms.
Come back for those.
Yeah, we can come
Yeah.
back for this.
What do you think, Mr. Ward?
I have no objection to that approach. If you took a different approach, I would suggest that simply need to add a condition on there that says permission shall first be granted before the erection of any day rooms or other structures on the site, which just makes clear that there isn't a permission for those items on site.
In effect, you're saying, Mr. Masters, that given what's before me and before the inquiry, with no details of the day rooms at all, that perhaps the description of development should be amended in respect of C and D?
I think so, sir. Bearing in mind that there are absolutely no details at
Yeah.
all, and it hasn't been something that anyone's consulted on.
Yes,
And I think the description should be amended to exclude it.
so that it's simply provides for
Is it-
the hard standing, the use and the two caravans.
Indeed, I make the points that when you go to the site, you're going to see in relation to Mark Doherty, the extra mobile of his brothers, but that's no part of our application either.
Oh, that's, yeah, I understood that from when he gave his evidence.
Yes.
Mr. Ward, are you happy with that approach that we?
Yes,
the
I
description-
would be happy to have them simply excluded.
Yeah,
Obviously, sir, the knock-on effect of that is that any harm that you find will be reduced because the day rooms won't be there.
because yes, it won't include that element of built development. Yeah. And that just leaves me, I think, with one point to raise, which is another possible occupancy condition. And if I were minded to find for the appeals because of personal circumstances, there should be a personal occupancy condition. And that's hence my request the other day for the list of adults on the site, which I know the parties have, main parties have got in hand.
It's
Yes, with
coming
regard
us at-
to appeal B, we sent them to the case officer earlier
Right, well,
today.
That will,
I
that will
realise
catch
that,
up with Minister Woods.
yeah. So they sent, we said it as requested by the inspector, so you
Yes.
should get that for
Thank
appeal
you.
Bs.
And is it in hand, Mr. Masters?
It is, so we did do it, but we realised that we needed to amend it, so it is coming tomorrow morning or
Fine.
tomorrow afternoon when we come
Yeah.
back.
Mr. Ward, are you content with that approach? Personal circumstances need a personal condition.
If you end up considering a personal permission, then yes, it should be specific and personal, and a list of occupants would be helpful,
Yes.
although obviously accepting that further children may come along or whatever, but that would simply refer to siblings or.
Yes,
It's
sorry,
very
Mr.
relevant to allaying the community's concerns that it would be unstoppable march if you allow this one. Because if it's personal, that's personal to them because of their profound medical need.
Yes, so I mean, the normal form of your words would be to specify the adults and resident dependents. Well, that brings me to the end of the points that I had to raise on conditions. So there, anything else that parties think could be appropriate?
On
Mr.
conditions, no, sir.
Okay,
No, sir.
right. Thank you. Right, Mr. Cottle, you.
Yes, well, I was just tidying up for the purposes of going through as you put things to one side to leave out what you're going to address in closing submissions. And I've got a document, and Mr. Ward has helpfully confessed that he's got the same document, which is a Surrey Hills AONB boundary variation project, which has got a cross on it marking the appeal site. And it shows the boundary extension of the AONB, now the National Landscape, and the proposed additions and the proposed deletions.
This
And
rings a bell.
I didn't know. Well, we think that Mr. Dudley spoke to it, but my learned friend can't recall. And I think we're all agreed that we can't identify it where it is in the papers, but we are carrying it around with us. And I've had it since November 2024, and it came to me at its inquiry.
Is it this one?
That's it. So what, that's good.
Yeah, I think that's the
What-
one, Inspector.
What document is that?
I'm just looking for I've been scribbling ID numbers on them when I've been told them.
I don't think it's got an ID number.
Unhelpfully. I haven't put one on, so.
Well, that's why I'm raising it.
If I
Because I
put it
was
in the,
pretty sure that
if I have it
wasn't-
in this file, it's been given to me during the inquiry.
Exactly, that's how I've got it as well. It's come to me during the inquiry. But I wasn't happy to refer to it in closing submissions unless I knew it was before you.
It
And
is
so I'm just
before me.
clarifying it.
Now,
So
you said it had a cross on it, I think.
mine's got a cross on it from where the appeal site is.
Right.
Yeah. I just wondered what document, we could give it a number. 21,
Find an electronic copy of the plan.
22.
We can add that as the next one, Inspector, to the next.
Yes.
And could I also ask back the document that we didn't have quite time to digest that came in at lunchtime? I just haven't had a chance to absorb what is in the email about the,
Oh, yes,
and I wanted Mr. Wood to have a chance to see it.
yeah.
And I don't know whether you remember, but there was another point during the first need discussion where Mr. Jarman was pointing out that section 225, which requires authorities to carry out an assessment of accommodation needs of gypsies and travellers residing and resorting to the district, has been repealed. And I was pointing out that no, there's now a statutory duty to consider the needs of people residing in or resorting to that district with respect to the provision of sites on which caravans can be stationed. And so he was saying, well, it's not particularly in relation to gypsies and travellers. And I'm saying, well, no, it's to do with people who are residing or resorting in caravans. And so you might think we're both right, but I wanted to hand up section 8 of the Housing Act 1985, which is on that point.
Yes, sir. I'm happy with that, Mr. Cottle. Have you got a copy for? It's... Right, you wanted to come back to the email, Mr. Cottle.
That's all. I just wanted time just to have a look at what it was said, because I'm very uncomfortable with emails that you're assuming knowledge of that I don't know what it said.
Yeah, it was certainly sent to Mr. Woods on the 18th at about midday, but yeah, I'm happy. So I assume that all the appellants would have seen it. Are you okay with that, Mr. Cottle?
Very helpful. It does refer to an attached plan, but I'm not sure it refers to
The
my
plan's
client.
here.
I think
It's just a revision of the plan that came in originally. It's the- So which loan, Mr. Masters?
If you go through, when you go up the site, you'll see a gate.
Don't know about Dunsfold Lane. There's Dunsfold Road, is that?
behind Thomas keeps his horses, there's a way out onto Dunsfold Road through a gate. It's only relevant to the exception test, but we haven't put that to Mr. Smythe in evidence.
But so it should be shown on the plans. So you have to see the gate up there.
Well, I think the email mentions that. I think that's been suggested by Mr. Bennett, talking about the route, Mr. Bennett, for the site visits. Because I think you made the point about being careful because there aren't footways along Dunsfold Road.
Yeah, it's an it's not it's fairly well used as well. I mean, there is, but it's sort of grass and woodland. It's just not ideal.
Yeah,
There's no footway.
But I
It is open access common land actually, so you can walk on the
but
grass.
I think your suggestion is go along Dunsfold Road, heading west and then cut off to go to the higher land. That's how I read the plan.
Yeah, I've not actually put a route on the plan. Of course, it's roughly circular route, yeah.
But
I do have an interest. If you started at Thatched House Farm and walked west down Dunsfold Road and then went up into the countryside, I would depart after you came back from the countryside, and then you would go on to the appeal sites and I would have time to do my closing submissions. But if you go to the appeal sites first, I don't know what's there, but I mean, I'm more concerned to accompany you up on the views above.
Inspector, I'm not proposing to come with you on the site view because it's an inquiry and we can't address you or say anything to you. It's just identifying things, and we're going to have
that's fine.
a witness to do that.
I
So
wouldn't necessarily expect you to.
just want to make that clear, yeah.
Yes. No. But as long as I see everything that the parties want me to see and what I want to see, I don't mind which order we do things in. I'm happy to start at Thatched House and walk up from there. Right, before I lose it, can I have my email back, please? But essentially, what's involved in terms is Thatched House, the appeal sites, Dunsfold Road, and then going up what I think are the lower slopes of Hascombe Hill, and returning via footpath 277. And I said earlier on in the inquiry, I'd like to go up Stovolds Hill as well, to the south, towards where the access was to Dunsfold Aerodrome. Now, in terms of participants on the site visits, let me just take some for the appellants. I mean, Mr. Woods, I presume it's yourself. Yes. And of course, you're representing appellants A and B. Is somebody else coming for C and D, or are you going to? What's the position there?
No.
But I can get onto this appeal site C and D. Has that been
You have to ask Mr. Masters.
Mr. Masters?
Sorry, as I understand it, both my clients
Yes.
are going, well, Matthew's not going to be there, but Mark is, and we got it round the right way. Matthew's wife is going to be there, so you'll be.
But I will be able to get onto both sides. Right. And in terms of the remainder of the site visit, clearly I'm going to be accompanied by the other parties and Mr. Woods for A and B. Are you content that that's the case, that there won't be anybody specifically representing your clients?
Unfortunately, so I am.
Yeah. But
I would like someone to be there to assist.
But if things are being pointed out in respect of the other sites which are nearby, hopefully that's satisfactory.
I don't think any prejudice in the case.
Yeah, good. So I've got Mr. Woods, and for the local planning authority, Mr. Ward.
Yes, sir, I will join you for the duration. I'm not sure if we may have other people who join for parts of the site visit, but.
As I understand it, Inspector, there'll be Mr. Smythe will be there in case there's any flooding things to point out. I think Mr. Sibbett will be there, and Mr. Dudley will be there for any landscape issues, I think.
Right, it's
Right.
that's quite a number. Mr. Ward. Yeah, I've got 4 from the local planning authority.
I object.
Well,
I'm sorry, I spoke too many. 2 is fine, 4 is ridiculous.
my concern, Mr. Winters, essentially is that when I have a larger number, and I've extended an invitation to the parish council, is there's the risk that somebody thinks they've pointed something out to me, and because of the number of people that are there, it becomes difficult.
I don't think that's appropriate, particularly with then we've got other people. Will then help, we can then start having a complete crowd before you control them.
Mr. Ludley.
Well, I think council needs to rethink their numbers.
Well, I can understand Mr. Dudley. Do you need Mr. Sibbott?
I mean, Inspector, I'll be guided by you, really. I mean, I think you're right, Mr. Dudley ought to be there.
Yeah,
I
can
think
understand.
probably Mr. Sibbott, you can keep in mind the points and evidence that he's given you. So I don't see why necessarily, if you're happy that he isn't needed, then that's fine. And likewise with Mr. Smythe, really. I mean,
Those are the two that I would perhaps question.
yeah,
If I have Mr. Dudley, I've got Mr. Ward, who will be, I'm sure, familiar with points that
yeah. And then,
may need pointing out in terms of physical characteristics.
and then if there are any extra points that are particularly in mind of Mr. Smythe and Mr. Sibbott, then they can relay those to Mr.
Yes.
Ward, and he can let you know. So I would suggest.
I
doing
think I
like that.
prefer that as the way forward.
So that we'll just say,
And Mr. Cottle, did you wanted to attend part of the site visit?
I do.
You know, I've no objection to that in principle. There's the related point that you were making about time for closings. As things stand, I can't really offer you more time in terms of closings. It's if we do the site visits tomorrow morning and then we defer closings, I'm going to have great difficulty, not an impossibility, of fitting those in at a subsequent date.
Well, we're in your hands, sir.
Yeah.
We hear what you say. I wanted an opportunity to have a little gap between the evidence and
Yes,
longer than I've got.
yes, I understand that. But from what you said earlier, if you did part of the site visit and then broke away, you can accommodate that. Yeah.
so two things.
Yes.
One, Mr. Rose, got
So-
a colleague here, James, who may be able to attend tomorrow for site C and D. He's trying to do his best.
So the gentleman you're pointing out is who?
James Brazil.
I can't pick it up.
So he's been asked to assist. He's a are you a qualified planner? No, he's a trainee planner. Who's been along for a number of days here. So I think he's doing this pro bono. But if he can, he'll attend tomorrow.
In respect of sites C and D.
C and D, yeah.
Right. Well, just to the mechanics of organising the tomorrow, I need to give a resumption time for the inquiry. Given the estimates you've given me, closings are going to last around about 4 hours. I've got to finish again by 5 o'clock. So I think we need to start the afternoon session at 12:30 to ensure we do that. Which means, I think, an early start for the site visits. I hope that doesn't cause any inconvenience, but probably the way the weather is, that's not a bad idea in any events, that it would be a cooler part of the day. If we can meet at the council offices, Mr. Woods, were you offering to drive?
Yeah, yes, sir. I won't be able to get in, so I can park at the entrance to the council offices.
Yes.
Where the barrier is. I'll park there.
That's off the berries, is it? Off the back road?
The barriers,
Yeah.
Yeah.
If
Well,
I can't get
where
into...
the police, you see the police cars
Yes,
parked up,
where the
yeah.
police cars come
So
in.
just at that entrance
Yes.
there.
So will you'll take myself and Mr. Ward, will you?
Yes,
And Mr. Cole.
and you as well.
But you've got to get back.
I thought you said you were coming back.
Yeah.
I'm really confused now. And I have a white Skoda Kodiaq.
Right. And I was going, well, I think we need quite a bit of time to cover what we're going to cover. My suggestion, and I hope it's not too early, is 8 o'clock.
Always too early, sir, but I'm sure I'll accommodate him.
Mr. Ward, can you?
The problem is that Ian Dudley was coming down specifically, Ian Dudley was coming down specifically for that, and he had difficulties getting here early, so 10 o'clock was a struggle for him, but 8 o'clock would definitely be a struggle, so we'll need to speak to him and see what's the earliest he could manage, because he'll come down in the morning, you see, rather than last night.
Yes. Well, the afternoon session is resuming at 12:30.
It's difficult, yeah.
It's very difficult because
Is it,
we need to travel back from the site, get ready and set up for the afternoon.
so would it be possible to do, because you're doing the part nearest to the site first, aren't you, presumably? I don't know.
Yeah, Mr. Cottle suggested start at Thatched House Farm and then do the circuit from there, which I'm happy with.
Yeah. I think we're going to have to give him a call, Inspector, but if we need to get, I mean, perhaps obviously as late as possible while still managing to get through in time to start the inquiry at 12:30 is all I can suggest. And we'll try and get him there.
I mean, that's the way I've dealt with it, sort of working backwards in terms of, I think we need to be back here by no later than 12 o'clock, and that's cutting things fine for a 12:30 start. And allowing for travel time there and back, I can't really see how I can do it much later than 8 o'clock. It's
Gonna have to ring him and tell him. Well, you can start as early as he starts, depends how much you're paying for it. Okay, we'll have to have that conversation. So yes, we'll have that. I think, I mean, in terms of your position, Inspector, that's quite understandable. We'll have to try and do our best with Mr. Dudley to get him there.
okay. Thank you. So I'll meet Mr. Ward and Mr. Woods 8 o'clock outside the offices where the police cars are. Mr. Woods, if I can't get in this building, then I've got a pass, but it may not work at that time. Have you got room in your car for my case?
For your
Case.
yes.
And then other parties such as Mr. Dudley, Mr. Cottle and Councillor Sullivan, they need to meet us on site where we start the site visits. So if we're starting at Thatched House Farm, I was told arrangements had been made for us to go there. Is there somewhere cars can pull in?
Yeah, that's correct, sir. Gates open automatically, ample parking. If you go,
So we can pull in off Dunsfold Road?
that's correct, yeah, through the main access and then just down to the house.
Right,
Yeah.
and would they be happy for us to leave the car there while we do the circuit?
Yes, he'd be more than happy, yeah.
Right, good.
Could I ask you, let Mr. Ward know the postcode for that, please? That would be very helpful.
Right,
Thank
good.
you.
Good, I think that covers it then. Anything else, Mr. Cottle?
No, thank you very much. I'll see you at Thatched House Farm.
Mr. Masters, anything else?
So the only thing from us is in respect of the DS sites,
Yes,
I've been having Mr. Jarman look at those now. And it is as I indicated that DS 18 and DS 20 are
18 and 20.
18 and 20 are included within the information within the GTAA, but 15, 16, 17 and 19, so the others would be new permissions that would affect the 5-year supply of pitches.
so they're not in.
So they're not in, no. So I've asked him to provide a note on that, and obviously we'll circulate that so that you can see what the position is and people can
Right.
make comments on that.
Okay, thank you. Right, the inquiries. Mr. Bennett, okay to leave things overnight?
Yeah, absolutely.
Thank you
Yeah.
very much. Inquiry is adjourned. We'll resume the inquiry at 12:30 tomorrow. Thank you. Now what do I need for the site visit?